Good morning, everyone. So we'll get started now. Hopefully everyone can see my PowerPoint, but I think we're good to go. So today is a living trust presentation. My name is Georgina Lepe. My office is located in Claremont. My contact information is on this first slide. I'll come back to it at the end of the presentation if you need to write down my information. I will be taking questions until the very end. So I do ask that if you have any questions, hold off until the very end. At that time, submit your question on the Q&A, or I guess you can unmute yourself. But I get distracted if I'm, going through the presentation and I see comments coming in. So I do ask that just to hold off on your questions because it's very likely that I will answer your question during the presentation. So it just kind of gets to be a bit redundant if I see the question when I already addressed it during the presentation. So a little bit about my office. Obviously, I handle estate planning, which we're going to discuss today. I create trusts, pour-over wills, financial power of attorneys, advanced healthcare directives, and all the other miscellaneous documents that you need in order to prepare for the future and make sure you have your affairs in order. I also handle probate and lastly, real estate law. Today, this is what we're going to cover. First and foremost, we're going to go over some key terms. I want you to know what we're talking about during this presentation. Then I'm going to go over the 3 estate planning options that I always tell my clients that they have when they come into my office. Um, the downfall of adding children on title to property. I know a lot of my clients come into my office and they tell me, well, Georgina, I don't want to spend money on a living trust. I'll just add my children on title. And today we're going to discuss why that is not a good idea. The downfall of joint tenancy. And like I mentioned at the very end, we'll open it up for questions. Key terms. During this presentation, when I am referring to your assets, we are talking about your home, your rental properties, bank accounts, business interests, you realtors that may possibly have a corporation or an LLC. That's an asset that ultimately needs to be transferred into the name of your trust. Timeshares, investment accounts. So though whenever I refer to assets, I'm talking to anything that you've acquired during your lifetime. A will is a document where an individual nominates an executor, a family member, to carry out the probate proceeding and lists who the beneficiaries are. These are normally the decedent's children or nieces and nephews, parents. So, will is a very simple document. It's normally 3 pages. It identifies the decedent, it lists their family members, who the executor is going to be, and who will receive the assets. A lot of people get confused with these terms, executor, trustee. Just remember, if there is a will, you're dealing with the executor. Next, we're going to talk about probate. Probate is the court supervised process that gets initiated when someone passes away. In the probate proceeding, the judge has to admit the will, if there is a will, and appoint the person listed on that will as the executor. Or if there's no will, appoint someone as the administrator. This individual, if you don't want to get confused, just refer to them as a personal representative. The term personal representative refers to executor or administrator. But do remember that if there is a will, there's an executor. If there's no will, it's an administrator. Probate is necessary whether you pass away with or without a will, and we'll get into that. But that's where a lot of people get confused, that they think that just because they drafted a will, they're protected and that their kids will avoid probate. What is a living trust? It can be referred to as a revocable living trust, a family trust, a trust. It all refers to an agreement. It's an agreement that a person, either a single person or a married couple, create during their lifetime. In that agreement, the grantor, who is the trustor, and the original trustee, because they're in charge of their trust, they list a successor trustee, someone to manage their assets in the event of a disability or passing. In that agreement, certain individuals are listed as the beneficiaries. So whenever you're dealing with a trust, you're dealing with a trustee. You're not dealing with an executor. And this is where a lot of people get confused. They come into my office with a trust and they are, referring to a certain individual as the executor. No, if we have a trust, we're dealing with a trustee. If we're in probate and there's a will, you're dealing with the executor. If there's no will, you're dealing with administrator. And so you don't get confused. You can just refer to these two individuals as a personal representative. So those are the phrases I wanted to go over. So option number one, when people come into my office and say, Georgina, tell me about living trust. I always have to start from the beginning because I want to make sure that my clients understand the benefits of having a living trust. I just don't want them to create a trust because their neighbor told them to get a trust. So option number one, you don't plan. I think many of you are possibly guilty of this, where you don't have a will, you don't have a trust, you have nothing in writing. You haven't planned for the future. Who's going to receive your assets upon your passing? Nothing. If you do not have a will or a trust, you will have to initiate the probate process. Well, not you, but your children, because obviously you would have already passed away. So in that probate process, the court will appoint an administrator to manage your assets. Since you did not leave anything in writing, your assets will be distributed to your heirs at law. What does this mean? If you're person, all your community assets will go to the surviving spouse. Even though you have a surviving spouse, you may end up in probate court because title controls. If you're married and your spouse is not on title to your primary residence or your investment property, in order for your spouse to claim ownership or be able to sell those assets, they will have to initiate probate. In the probate process, obviously the judge is going to appoint an administrator and have that administrator begin the administration process. In probate, we have to publish it in the newspaper. So if you have any creditors and they have hired a company to keep an eye out on the newspaper to see what probate cases have been initiated, they can file a claim. Your personal representative has to notify all known creditors. So I always tell my clients, the administrator, you have to check the mail. Any bills that come in, we have to provide them notice of the probate proceeding. Why? Because if they have a claim against the decedent, they will have to file a creditor's claim in the probate proceeding in order to get paid. We also have to notify the Franchise Tax Board, the IRS, and Medi-Cal. So if you or your spouse have received any Medi-Cal benefits and we're probating your estate, Medi-Cal will file a claim. I've had cases where Medi-Cal will file a claim for 150,000, 170,000. So obviously they have to get paid before your children receive their inheritance. Another thing to keep in mind is that title controls. For those of you that own properties with someone else, it's imperative that you look to see how vesting is. Is vesting as joint tenants with the right of survivorship? Is vesting as tenants in common? So I'll give you an example. Let's say you and a sibling, whether it be your brother, your sister, you both own an investment property. You take title as joint tenants with the right of survivorship. You pass away, your interest automatically goes to the surviving joint tenant, your sibling. So in that case, if you're thinking that your 50% or whatever interest you may own in that property is going to your heirs, that will not be the case. We're not going to open up probate for that house. So that's why I always tell you title controls. Even if you were to have a will, so some people come to me and say, well, Georgina, my dad had a will, but he owned this property as joint tenants with his brother. That will doesn't even come into play because we're not opening up probate. By operation of law, when you passed away, your interest went to the surviving owner. So it's very important for you to look on title to see how vesting is listed on your properties. So just a brief overview of option number one. You have to open up probate. You didn't leave anything in writing, so the judge will determine who will receive your assets, and it would be your heirs at law. And I think that's where I lost my train of thought. But if you're a married individual, it goes to your spouse if you're married. If you don't have a spouse, it goes to your children. If you don't have any children, it reverts back to your parents. And if your parents are not alive, it'll go to your siblings. Option number two is having a will. And this is where everyone gets confused. A lot of my clients will come into the office and tell me, Georgina, I already have a will, I'm protected. What do I tell them? Your will is a golden ticket to probate. You still have to go through the probate process even though you have a will. The only difference is that with the will, you've nominated an executor, so you've told the judge exactly who you want to be in charge of the probate proceeding, and secondly, you listed your beneficiaries. So maybe you wanted to disinherit one of your kids. With the will, you would be able to disinherit anyone. So with option number one, we still have to publish in a newspaper, notify the Franchise Tax Board, Medi-Cal, and IRS. So why do we want to avoid probate? Probate is super expensive and time consuming. Normally it takes anywhere from 1.5 to 2 years to finalize a probate case. We as attorneys get paid a percentage of the value of the assets, and we're looking at market value. We're not taking into account how much there is in equity. We're looking at market value. So if a house is worth $500,000, which that's a very easy threshold to meet in the state of California. So if your house is worth $500,000, the attorney will charge at least $13,000. The reason I say at least is that we have the ability to ask the court to increase our fees. For example, if we had to sell the primary residence or any investment properties, we can actually keep track of our time that was spent assisting the realtor or drafting any documents that needed to be drafted for the sale. And in that case, we would be able to increase this amount. So this amount can possibly be $17,000 or $18,000. The personal representative, the family member that assists the attorney, is also entitled to that same amount that the attorney receives. And they get this without even going to law school or passing the bar exam. So 13 plus 13, that is $26,000. Obviously, the personal representative can decide to waive their commission, the statutory fee. But in most cases, even if my clients tell me, Georgina, I'm going to waive it, by the end of the day, they'll tell me, you know what, Georgina, no, I want to charge the fee because this took time away from my family. I had to ask for time off work. I feel drained. I feel stressed. So at the end of the day, if they do decide to charge their statutory fee, you're looking at least $26,000 in attorney and personal representative fees. Like I mentioned earlier, if the attorney asks to increase their fee, this figure will probably be about $32,000. That amount does not include the court filing fees, probate referee fees, creditor claims, and Medi-Cal claims. Like I mentioned, I've had cases where Medi-Cal claims are over 100,000. We'll have creditors file claims left and right, Verizon, Visa, MasterCard, and so forth. So all those creditor claims need to be paid off before anyone receives a dime. So that is one of the reasons you want to avoid probate. And I do want to mention that even if your kids are planning on keeping the home, they still have to go to probate. I've been encountering a lot of cases where the adult children come into my office and say, well, Georgina, we don't want to sell. We just want to add our names on title. Well, guess what? You still have to go through the probate process. The judge needs to appoint an administrator to have the ability to sign the deed, transferring ownership into the name of the intended heirs. And the judge also wants the creditors to be paid and, Medi-Cal to be notified and all the other agencies that are entitled to notice. So do keep that in mind. Even if your kids are going to keep the home, they would have to initiate probate. So this is a breakdown of the fees if you were to sell a home in the probate proceeding. So we're just going to go off the $500,000 value that I mentioned earlier. So on this side, this is if we're going through probate, and on the right hand side, if it's a trust sale, if the decedent actually had a trust. So assuming the house is worth 500,000, 200,000 is owed on the mortgage, whether it's a reverse mortgage or a standard loan. Then let's say a broker commission 5%, we're reducing 25,000. Closing costs, I just included 4,000. Attorney and personal representative fees, if we're going to probate, at least 26,000. And on the other hand, if it's a trust sale, you're not looking at the statutory attorney's fees. Estimated probate fees, at least 5,000. Obviously, you don't have this on this column over here because we're not going through probate. And remember, with this column on the left, I haven't included a row for any creditor claims. So if you're going through probate, the heirs will most likely split 240,000. If it's a trust sale, 271,000. So you can see that's a price difference of at least $30,000. I don't know about you, but I would be able to do a lot of things with $30,000. Maybe I would take 2 months off work and just travel all over Europe and say goodbye to my cases for some time. Yeah, so that's something definitely that you want to take into consideration. Option number three, and the reason why you're all here, a living trust. So, like I mentioned before, a living trust is an agreement that you create during your lifetime. If you're a married couple in your living trust agreement, you will indicate that you're married. And if you have children, you'll list your children. Um, with the living trust, it allows you to control your property while you're alive and able to do so. What does this mean? During your lifetime, you're in complete control of your assets. Yes, we have to transfer the assets into the name of the trust, but you are in control of the trust. So, for example, title to your primary residence needs to be transferred to the name of your trust. Instead of your primary residence having your name as a single person, or you and your wife's name as a husband and wife, title will get transferred to your name as trustee of your trust. So, for example, for my primary residence, title is held as follows: Georgina Lepe as trustee of the GL Living Trust. However, even though title to my primary residence is in the name of my trust, if I decide to sell, I can sell. If I want to do refinance, I'll be able to do that. If for those of you that are older and want to do a reverse mortgage, you have the ability to do that. So you're in complete control of your assets. I always tell people, think about it like a bucket. In that bucket, you have your living trust agreement, which are the instructions of how you want your assets to be distributed upon your passing. And then you have all your assets. So your primary residence that you transferred into the trust, it goes in that bucket. All your investment properties, if you have an LLC, we have to do an assignment of interest. If you have a corporation, your stock certificates need to be issued in the name of the trust, and so on. So while you're alive and able to do so, you're in complete control of your assets. If you were to lose capacity, the successor trustee would be able to take care of your assets and your loved ones. Because if you lack capacity, at that time, your successor trustee would take control of your assets and would have to make sure that you're taken care of. What if you were in the process of selling your home and you got into a horrible car accident and you lost capacity? Obviously, you don't have the ability to engage in a transaction, so you can't close escrow. So if that were to happen and your property is in the name of the trust, the successor trustee would step in your shoes and continue with the sale. Or let's say you fell ill and you need to sell your home because you need to pay for your care. then your successor trustee would be able to list your home for sale, use the proceeds to provide for you. Give away your assets to certain individuals with your own restrictions. Since you have a trust, you're able to indicate who's going to receive your assets and how they're going to receive them. Many of you probably have minor children. You don't know if they're going to be responsible when they become of age. And you think to yourself, well, if I pass away and they're 18, I don't want them receiving their inheritance at that time. If so, they're probably going to be at a day club in Vegas every single weekend and just blowing money. So I want them to have the ability to use their inheritance to pay for their education, healthcare, and support, but I don't necessarily want them having access to their funds. So if that's the case, we can actually stagger the distributions and indicate, okay, once the minor reaches the age of 21, they're entitled to a third. Once they're 25, they'll get the second third, and so on. You can also include your own restrictions in the trust. What if you have a very responsible child and they say, well, I'm 18, I want to buy a home. Well, then in your trust, you can include if any children of mine wish to purchase a property, then the trustee can transfer that money directly into the escrow account. If you want to disinherit certain individuals, you can. Those of you that have special needs children, it's very important that you include a special needs trust within your trust so that your children don't lose their government funding. So that's definitely something you want to take into account with blended families. If you have children from different relationships, it's very important that you sit down and have a trust and provide for your children and make sure that they're protected. Because like I mentioned before, title controls if you don't have a living trust. So if you and your spouse are on title as joint tenants and you pass away, your interest in that house goes to your spouse and he has no legal obligation to share any part of that inheritance with any of your children. Without unnecessary cost or undue delay. So if you have a trust that's properly funded, you're going to avoid probate. A lot of people think that just by having their trust, they're avoiding probate. And no, no, no. You need to make sure that everything is actually titled in the name of the trust. So I always tell people do an inventory of your assets, make a list, indicate whether that asset is titled in the name of the trust. Do you have a beneficiary designation? And then that way we make sure that everything is either titled in the name of the trust or it has a beneficiary designation. Here's a comparison between a living trust and a will. With a living trust, you avoid the costly and lengthy probate process. With the will, it is the golden ticket to probate. A living trust protects you in the case of a disability. Like I mentioned earlier, if you were to lose capacity, your successor trustee will take control at that time and manage your assets for your well-being. A will does not plan for disability because a will does not get admitted into the probate proceeding until you pass away and someone initiates probate. With a living trust, Medi-Cal liens are avoided. If you have a living trust, Medi-Cal cannot seek to get compensated for all of the services that they provided to you during your lifetime. On the other hand, if we're going through probate, whether you have a will or not, but we're going through probate, we are legally obligated to provide notice to Medi-Cal that you have passed away and that a probate proceeding has been initiated. So if you have received any Medi-Cal benefits, then we will have to pay them because they will file a claim. We cannot close out a probate proceeding without Medi-Cal being notified. We actually have to show proof to the court that we received a response from Medi-Cal indicating that no claim is owed. With the living trust, blended families are protected because like I mentioned, if you pass away in your living trust, you can provide for a distribution for your children at that time. Or maybe you have the entire trust become irrevocable upon your passing so that your surviving spouse cannot make any changes. And then once your surviving spouse Once the surviving spouse passes away, your children will receive their inheritance. With the will, children from blended families can be disinherited because remember, we don't open up probate in every single situation. We only open up probate when the decedent is the only one on title or they held title as tenants in common. So this takes me back to joint tenancy. If you own something as joint tenant, husband and wife with the right of survivorship, it's automatically going to the other owner on title. However, if you're the only one on title or you own that property as tenants in common, then we'll go through probate and your will get admitted. But like I mentioned, if you own title as joint tenants and you pass away, your will doesn't come into play. What about adding your children to title of your property? This is a horrible idea, yet a lot of people do it because they want to avoid the expense of having a living trust. And they tell me, well, Georgina, at the end of the day, I wanted to go to my children. So I'm just going to add them on title. So when I pass, it automatically goes to them. This is a great way to have your children's creditors go after your property. If your children get sued and a judgment gets signed, an abstract of judgment can be recorded against them in the county where they own property. So if they're entitled to your property, guess what? If you ever go to refinance or sell, that claim will need to get paid. Also, you lose control over your property. If your child decides to get a divorce, in that divorce proceeding, all of the owners of that property will now be parties to that divorce proceeding and the property will get sold. So I've had cases where people had their kids on title and then the kids go through a divorce. Guess what? That spouse isn't going to be so nice because they're going to want to go after the property that you own. Also, if you have a falling out with your children and they decide that they want their inheritance early, they can actually file partition action to force the sale of the property. Also, you're having your children pay high capital gains taxes. It's always best to inherit a property because then the value of the property gets determined at the time of your passing. So if your children turn around and sell the property, there's really not going to be a gain because if they inherited the property, the value got determined at that time and they turn around and sell it, then there's no gain. On the other hand, if you add your children on title during your lifetime, they inherit your tax basis whenever they go to sell. They're going to have to pay capital gains taxes on the difference of your purchase price and their sales price. Here's a breakdown of the capital gains taxes. So let's say the parents purchased a property in 1986. At that time, the property was valued at $250,000. The parents add the children to title in 2010. Now the property has gone up to $500,000. The parents pass away in 2040. The property is valued at $700,000. Immediately after the parents passing, the children decide to sell the property for 700,000. They will have to pay taxes on a gain of 450,000. Capital gains taxes combined can be anywhere from 20 to 40%. So if we take the 40%, it's 180,000 that they will have to pay in taxes. Obviously, they can do a 1031 exchange to defer the payment of taxes. But if they elect not to do a 1031 exchange or no one tells them that it has to be done when they sell this property, then they're going to be stuck paying about 180,000. Same scenario, except that the parents do not add their children on title and they actually have a living trust. So by the time the parents pass away, it's worth 700,000. The children sell it for 700,000. Their gain is zero. What about joint tenancy? With joint tenancy, it doesn't protect blended families. If you're part of a blended family where you or your spouse have children from different relationships, you are potentially disinheriting your children. I'll give you an example. Let's say wife has a daughter from a previous relationship, husband has a son from a previous relationship. They both get married, they buy a home together, and wife has an accident and she passes away. Since title was either as joint tenants or husband and wife, that property automatically goes to husband. And let's say husband doesn't do anything and 20 years go by and then husband passes away. Well, we're only going to probate husband's probate, so husband's sole heir is his son, and the asset is the home. So in that situation, the daughter that wife had from her previous relationship is disinherited. Individuals do not understand the legal implications of joint tenancy. Like I've been mentioning over and over again, if you own something as joint tenants with someone else, upon your passing, it will automatically go to that surviving joint tenant. Children added as joint tenants will cause issues. I've seen numerous cases where the adult children want their inheritance during their lifetime. They know that their parents have added them on title, so they go ahead and sue the parents in essence to force them to sell the property so they can cash out on their inheritance. A lot of people do tell me, well, Georgina, my husband and I will own our assets as joint tenants, and then once one of us passes away, at that time we will create a living trust. The problem with that is that you're assuming that when one of you passes away, the surviving joint tenant will have capacity to prepare a trust. So let's say husband and wife live a very long life, wife passes away at 90, and then now husband needs to create a living trust because that was the plan that when one of them passed away, they would create a trust, but now husband lacks capacity. We're back to square one. They're going to end up in probate. So what is included in my estate planning portfolio? I include the revocable living trust, which is about anywhere from 80 to 100 pages. If you're a married couple, each of you gets a pour over will. If you're a single person, then obviously it's just one pour over will. The purpose of the pour over will is to transfer any assets that may end up in probate into your trust. Like I mentioned, if you pass away, even though you have a trust, if your assets are not titled in the name of the trust, you will end up in probate. Each of you gets a financial power of attorney. My financial power of attorneys are about, I want to say 25 pages. It includes every power under the sun. So if you were to lose capacity, you're nominating someone to make financial decisions over the assets that are outside of the trust. Obviously, if your assets are in the trust, your successor trustee would be able to make financial decisions over those assets. However, what am I referring to? Let's say you lost capacity and you were in an automobile accident and you need to sue. Obviously, since you lack capacity, you don't have the ability to hire an attorney. So the agent listed on your financial power of attorney would have the ability to hire an attorney or go in front of a judge on your behalf. That also includes dealing with Social Security, any bank accounts that are outside of the name of the trust, and the list goes on. Also, you get an advanced healthcare directive. So if you do not have the ability to make medical decisions, the person that you listed on your advanced healthcare directive would be able to make those decisions for you. And you can actually include specific instructions as far as like, do not connect me to life support or only have me on life support for a month, 2 months, whatever the case may be. We prepare all the deeds to your properties. We pay the recording fees and the notary fees. These are my fees for a living trust. A single person with one home, it's 1,749. That includes the recording and the notary fees. If it's a married couple with one home, it's 25.99. Each additional property is at $300 because we prepare the deed and pay the recording fees. So if you'd like, the first step would be to schedule an appointment. There is a fee for my appointments. However, this does get applied towards a final trust fee. You can either book online or by calling the office. So essentially, since you already attended this presentation and we went over the benefits of a living trust, that first appointment that you have with my office, we can actually go over the instructions if you complete an intake form prior to that appointment. And then the last appointment, that's the trust signing appointment. That normally takes about 2 hours because we go over all the documents that we have prepared. Everything gets signed and notarized. But normally, it takes 3 meetings. One, the initial meeting where I go over the benefits of having a living trust, essentially what I did today. But many of you, if you're married, obviously your spouse maybe didn't join you today. So they would probably want to come in and get more information. So that's the first appointment where I go over the benefits of having a living trust. The second appointment would be to go over the intake form. I give you a form to complete, and based on that intake form, we prepare your trust. And like I mentioned, the third and final appointment would be for you to come in to sign your trust. I'm going to open it up for questions now. So you can either submit your question in the chat, but I think you guys can also unmute yourself. So I guess if you raise your hand, I can unmute you, or
I think they can unmute themselves.
okay. So let me open up the chat. Are living trusts state specific? For example, if I own in both California and Nevada, would I need to have a trust in both states? That's a good question. So you would have a trust in the state where you reside. So if you reside in California, you would have a trust here in California. We would then need to hire an attorney in Nevada to just prepare the deed transferring ownership of that property to your trust. So the trusts that are created here in California have jurisdiction over property all over the United States, but it stops there. Obviously, if you have property in any other countries, you would need to establish a trust or a will in that country. Question: if the property is titled in the name of the trust, the trustee passed away 10 years ago, the property is in the trust. What documents do we need from the beneficiary to list and sell the property? That's a very good question. A lot of people do not administer the trust. And I see a lot of complications here. So one, you as a listing agent, I'm assuming you're a realtor because you said, what do we need to list and sell the property? One, you want to see a copy of the trust, and you want to turn to the section where it lists the successor trustees. You want to make sure that you're dealing with the individuals that actually have the authority to hire you. Because remember, a beneficiary doesn't have control. It is the trustee. So for example, if someone has 5 kids and they're all listed as beneficiaries, but the trustee is a family friend, then the trustee is the one that has the authority to hire you. So get a copy of the trust. Secondly, do request the last recorded deed from your title company to confirm it is in the name of the trust, and also a death certificate to confirm that those individuals have passed away. In the escrow process, the title company will require an affidavit of death of trustee to be signed by the successor trustee. That form basically indicates that the initial trustees have passed away and now they're dealing with new trustees. One issue that I see here, Sharon, is that the property will most likely get reassessed if the children never submitted the parent-child exclusion form. In order for property taxes to remain the same, especially since the decedent passed away 10 years ago, a parent-child exclusion form needed to be submitted. In the LLC, if the limited member has a living trust, what do we need from them? So if you're selling an asset that's titled in the name of an LLC, you need to see the operating agreement that lists who has the ability to sell the property and who the members are. If the living trust own a portion in TIC, will the TIC go through probate? What is TIC? If you can.
It's a tenant in common.
Oh, okay. Oh, okay. So if someone owns a property and tenants in common, they need to transfer their interest in that property into the name of the trust. So I own a property with my brother. I transferred my ownership interest into my trust. Or well, it's either my trust or my LLC, one of those two. But regardless, my LLC assigned its interest to my trust.
So if let's say if one of the trustee passed away, will the whole TIC go into probate or just
No,
their
just
portion?
the percentage that the decedent owned would have to go through probate. So if the decedent owned 30%, 50%, that is the percent that will have to go through probate. There may be other options available depending on what the value of that interest is. I normally go over that in my probate presentation, but have the clients, if they want to schedule an appointment, if at the time of passing, the decedent's interest in that property was under 166,000, you may be able to avoid the full-blown probate and go through a summary probate process. The benefit of a summary probate process is that the high attorney statutory fees do not apply. We do them on a flat fee basis.
I see.
So if the decedent died 10 years ago and he owned 50 or 30%, and that interest was under 166,000, the beneficiaries may be in luck.
Okay. And back to the previous question regarding to the LLC. So if we don't have anything in the operation agreement, does the general member still have the responsibility to ask the limited member about their document on the living trust?
So are you trying to sell or transfer the interest into the trust?
Transfer the interest to the trust.
Okay, so you would still need to look at the operating agreement because the operating agreement for the LLC most likely will allow it. But some companies may say you may not transfer your interest into a trust. So first and foremost, they need to contact the general managers to confirm that it's okay, and then we can just do an assignment of interest.
Okay, so we are actually the general member, and
Sorry,
my friend is the limited member.
Yeah, because you had 3 questions. So I do want to get to everyone. So I
Okay, all right.
want to ask you again. Sorry. Karen, do we need to hire an attorney to apply for the probate? Can the children apply for the probate on their own? Karen, like with any court proceeding, you do not need to have an attorney. However, I don't recommend that because probate, it's not an easy task. It's very confusing. If you mess something up, you're gonna end up, well, the children will end up paying more in fees, and that there's gonna be delays. You know, there's so much that we as attorneys do behind the scenes to get everything ready for the first hearing to make sure that the client gets appointed. I can guarantee you this: if the children move forward with a probate without hiring an attorney, they're gonna it's just gonna cause delays. Will the trust file its own tax return? While you are alive and you create a trust, it's like a pass-through entity. You're gonna continue filing your tax returns as you have been in the past. Once you pass away, and if the assets don't get sold or distributed and it's generating income, then the successor trustee will have to file its own tax return. Carmen, if title is unmarried, but he is married now, should he set up a living trust to add wife on it? Absolutely. Because if he passes away, since he acquired title when he was not married, that does not qualify for a summary probate proceeding, and wife would have to do a full-blown probate, and she may not end up with 100% of the property. If property is on LLC, can we put in trust? If not, will LLC go through probate? Good question. If you have an LLC that owns a property or properties, we have to do an assignment of interest, whereby you assign your interest in that LLC to the trust. Everything has to come back to the trust at the end of the day. I'll give you an example. I have a corporation. My stock certificates are issued in the name of my trust. I have an LLC. I have an assignment where I assign my interest in my LLC into my trust. My primary residence is in the name of my trust. All my personal accounts are titled in the name of the trust. And then I have everything in a binder because I do not want my family to go through what other families go through when we have to initiate probate. And do bank accounts have to be titled in the trust? Me personally, I recommend that at least one account is titled in the name of the trust. Why? If you were to lose capacity, your successor trustee will have access to those accounts that are titled in the name of the trust. So let's say you don't have any children, or you do have children, but whatever they make, they already have that committed to their mortgage, their kids' schooling, and so forth. So if you lost capacity and your accounts are not titled in the name of your trust, your children will not have access to pay for your expenses. Excuse me. And then once you pass away, I do recommend at least one account so that the children will have some funds to pay for the cost of administration. Any other questions? What should we do if we own different properties? Should we use one trust or separate? No, you're just using one trust. A trust is not like an LLC. A lot of people create separate LLCs to own separate properties, but no, a trust does not protect you from liability. The only purpose of the trust is to protect you in the event of your disability or passing. There's no creditor protection. So it's just one trust, and you transfer all your property there. Obviously, if you have several investment properties and you have them in different LLCs, then you would assign your LLC interest into the trust. Any other questions? You're welcome. Own properties and joint tenant. Do I need the approval from the other owner to set up a trust and put my properties in trust? No, you need to do it right away, because as you know, you pass away, it goes automatically to that surviving joint tenant. So it's very common for me to create trust, and then my clients will say, well, I own several investment properties with different friends or family members. We just prepare a deed transferring your ownership interest into the name of the trust, and that severs the joint tenancy. Can you put CD accounts in your trust? Absolutely. I would wait for the CD to mature. And then once the CD matures, then you're going to reinvest it. Then you can just put it in the name of your trust. That way, your trust has ownership of that CD. Any other questions? When should we update the trust? Whenever anything changes in your life. So if you want to disinherit a child, that would be a good time to change your trust. In reality, the trust is the foundation. So if in your trust, let's assume you have 2 kids, in your trust you indicate everything goes 50-50 to both kids, and that doesn't change during your lifetime, you don't need to change your trust. However, as time goes on and you're acquiring more assets, you need to make sure that you acquire all your assets in the name of the trust. So for example, you open up another investment account, you acquire ownership in the name of the trust. Throughout your lifetime, you're going to include a statement of all your accounts in the estate planning portfolio. So you pass away, your children will get your binder and say, okay, what accounts did mom have? And then in the trust, you're going to have all the accounts that you have. So then that way your children can go to those financial institutions. Should investment accounts name the beneficiary as a trust or a person? That's a good question. It can be either, as long as it's not like a retirement account. For retirement accounts, it's best to list individuals as beneficiaries. But if it's an investment account, you can list the trust as a beneficiary. What if the mortgage changed? We don't change the mortgage. When you're creating a trust, we're just transferring ownership into the name of your trust. The mortgage stays the same. However, with that being said, if it's a commercial property and you have a mortgage, you actually have to get permission from the lender to transfer ownership into the name of the trust. How much does it cost to add properties to the trust? I charge $300 to prepare the deed, the preliminary change of ownership, and mail it off and pay the recording fees. No, sorry, that wouldn't. Would that include? Yeah, that would include the recording fees as well. Fees are paid one time or any additional fees. Okay, so once you retain me, once you come into that second meeting, half of the trust fee would be due at that time, and then the balance when you come in to sign the trust. There's no administrative fee. However, if you need to make changes to the trust, then obviously I would bill you for those changes. The changes can be, the cost for those changes can be anywhere from $200 to $400. It just depends the extent of the changes. What other questions can I answer for you? Carmen, does a living trust protect you from creditors? No, I mentioned it earlier. A living trust does not protect you from creditors. It's as if you own the property outright. We're just avoiding probate. Obviously, for your investment properties, you can have different planning techniques in place that will protect you from creditors, like an LLC or a corporation. Should we put all bank accounts in the trust? Like I mentioned before, I would recommend at least one account being in the name in the trust. And if I create the trust when I reside in California, but at retirement I move to a different state, would that matter? It shouldn't matter because I think that state where you move to should honor your trust. So I don't think it would matter. I think that's it now. Any other questions?
I think that's it.
All right, everyone. Thank you for joining us. And until next presentation, I'll check my calendar to see when that is.
I think it's in August.
In August? Okay.
Yeah, we're doing evictions.
Oh, okay. Yeah, I'll definitely have an update because the law is going to change at the end of the month. So
Yeah.
it's either going to be extended or which I think it would get extended. So
Yeah. Well, thank you very much.
all right. Bye, everyone. Have a nice day.
Bye.